Hi, good afternoon and good morning to those of you on the West Coast. Thanks for joining us today on this lovely St. Patrick's Day to take part in the first installment for this year of our continuing CLE series, the McGuireWoods PFAS regulatory update, where today we're going to be talking about some of the most important developments from the past year in the federal and state regulatory space on PFAS issues, and then look ahead to what folks should expect coming up in this coming year as well. As I said, this is the first installment of what is generally a quarterly CLE series that we at McGuireWoods have been putting on, addressing PFAS-related issues. We had 5 of these last year, and we're hoping to continue the trend this year. Looking ahead for the rest of this year, we're looking at deep dives addressing issues like a specific focus on state issues arising in the PFAS space, transactional issues and SEC reporting, and then finally a litigation look back at the end of the year. So if you're interested in the topics we discussed today, I'd encourage you to follow along with us for the coming CLEs as well. Today, I'm happy to be joined by a great panel of 2 other fellow colleagues here at McGuireWoods, Preston Bryant and Naveed Nanjee. To introduce myself first, my name is Andrew Knudsen. I'm a partner here in the Washington, D.C. office of McGuireWoods, and I'm an environmental litigator. I represent clients in regulatory matters, as well as advising clients on PFAS-related issues under a whole range of different federal environmental regulatory statutes. And before joining McGuireWoods, I was a litigator with the Department of Justice, Environment and Natural Resources Division for about 5 years, where I also represented the federal government in a number of PFAS-related cases under various environmental statutes. I'll hand it off to Preston and Naveed to introduce themselves. Preston, why don't you go first and introduce yourself to the audience?
Thank you, Andrew. I'm Preston Bryant in the McGuireWoods Consulting. McGuireWoods Consulting is a subsidiary of the McGuireWoods law firm. I'm located in Richmond, Virginia. McGuireWoods Consulting, we handle public affairs and government relations services, and we have offices in 7 states and the District of Columbia. Prior to joining McGuireWoods 16 years ago, where I was consulting, I was in the Virginia legislature for 10 years, and I was the Virginia Secretary of Natural Resources, the Environmental Secretary in Governor Tim Kaine's cabinet. My practice here focuses mostly on environmental, energy, and local government matters.
Thanks so much, Preston. My name is Naveed Nanjee. I'm an Environment and Mass Tort Associate at McGuireWoods based in Atlanta. I previously served as U.S. EPA in the Office of Enforcement and Compliance Assurance as an attorney advisor in Washington, D.C. I was in the Office of Site Remediation Enforcement. And while I was at EPA, I served on the National Enforcement Team for PFAS matters under CERCLA. And my current practice focuses on environmental regulatory compliance, litigation, and crisis management incident response. I'll turn it over back to you, Andrew.
Yeah, thanks, Preston and Naveed. Really glad to have you both here with us today to run through these topics. I'll just give you here a brief overview of what we're going to be addressing today. First, in our look back at developments in 2025, we're going to start by looking at the broader PFAS plan that EPA issued in spring of last year, kind of laying out its strategy for the new administration. Then run through the status of the National Primary Drinking Water Regulations that EPA issued under the Safe Drinking Water Act for 2 PFAS in particular, PFOA and PFAS. Then the status of the CERCLA designations of PFOA and PFAS that EPA published last year, in 2024. And then finally, EPA's proposed changes to its Toxic Substances Control Act reporting rule for PFAS. Then looking ahead into 2026, there's a wide range of things that we could cover, particularly at the state level, but we've decided to focus in on a few of those for the coming year, focusing first on biosolids and states' efforts to regulate their use. and PFAS bans on consumer goods used in competitive sports, and looking ahead to some potential action on limiting liability for PFAS use and releases, which may or may not develop on the horizon. It's an updated EPA guidance on destruction and disposal of PFAS, which does seem to be slated for publication fairly soon. And then some potential action on disputes involving regulation of PFAS under the Clean Air Act. So kicking off, looking in general at the developments in 2025, there are a lot of questions heading into the first year of the new administration as to how they would go about addressing PFAS and whether or not they would continue to build on the previous administration's actions or take them in a new direction or walk some of them back. You may remember that in the first Trump administration, the administration began taking some initial steps towards regulating PFAS under several different federal statutes, and went so far as to create a published PFAS action plan with a number of items that EPA and the rest of the federal government were planning to take steps ahead on to develop further regulation. And the Biden administration, while issuing its own PFAS roadmap, in the process built on a lot of the things that were started with the PFAS action plan. But as the new administration came in, there were, again, a lot of questions about whether and how the struggle would play out between sort of a general deregulatory inclination under some of these statutes versus elements of the administration that wanted to go further, in particular, kind of the Make America Healthy Again movement, pushing for additional regulation of different contaminants, including, in particular, PFAS. There's also the question of how the administrator's own personal priorities might play into the administration's policies here. Administrator Zeldin himself, in his days as a legislator, had developed a kind of a track record of making PFAS a priority, including supporting some action to allow the use of CERCLA authorities to address PFAS. So that ambiguity was largely cleared up in the spring of last year on April 28th, when Administrator Zeldin announced the agency's new plan for regulating PFAS under its different authorities. And as a general matter, that 2025 action plan focused on three general themes. The first is taking steps to strengthen the science that EPA and others rely on to address PFAS. The second, what EPA called fulfilling its statutory obligations and enhancing communication. So this was an item focusing on further regulatory steps. And third, finally, building partnerships with state, local, and tribal governments to address PFAS. On the first prong of this action plan, the plan to strengthen the science included a number of actions like designating an agency lead within EPA to coordinate actions on PFAS, as well as implementing a testing strategy under TSCA Section 4 to develop additional information about PFAS and its health effects and other scientific issues. The agency planned to pursue further efforts to collect information and develop measurement techniques related to air emissions, which would kind of further set the table for the possibility of regulating emissions of PFAS under the Clean Air Act. And then finally, the agency announced its intent to provide more frequent updates to its PFAS destruction and disposal guidance. This is a guidance that was required by the 2020 National Defense Authorization Act to be issued and then updated every 3 years. But EPA's goal now is to try and update that guidance as often as annually. On the statutory piece and further advancing the administration's regulatory goals, these items included developing ELGs, effluent limitation guidelines, under the Clean Water Act that would apply to PFAS manufacturers, metal finishers, and potentially dischargers and other industrial categories that would apply for purposes of permitting under the Clean Water Act. EPA also announced that it would plan to address what it called the most significant compliance challenges and requests from Congress and drinking water systems related to its regulations under the Safe Drinking Water Act for certain PFAS. The agency would enforce the Clean Water Act and TSCA limitations that had already been issued on PFAS use and release, as well as use its CIDWA authority to try and address immediate endangerment from releases of PFAS. And that it would work with Congress and the industry to establish a clear liability framework operating on polluter pays and the principle that would also protect passive receivers. And this seemingly was a reference to further development of and refinement of treatment of PFAS under CERCLA. And then finally, on the building partnerships prong, the general theme here was supporting state and local efforts, both to clean up PFAS in the environment and to pursue enforcement actions under existing authorities. So EPA, for example, committed to advance remediation and cleanup efforts where drinking water supplies are affected, and work with states to try and identify risks from contamination and develop additional tools for risk assessment and analysis, as well as providing assistance to states and tribes on their enforcement efforts, and reviewing and taking action on pending state air petitions for regulations under the Clean Air Act. And then finally, to provide resources and support investigations into potential violations to hold releasers of PFAS accountable. So where the rubber has met the road is in some of the actions EPA has taken with respect to specific regulations issued during the Biden administration. The first and one of the most significant involves EPA's National Primary Drinking Water Regulations, or what we often call maximum contaminant limits, MCLs, for 6 PFAS compounds. In April of 2024, EPA had issued those MCLs for 6 different PFAS. The first 2 being PFOA and PFAS, which are subject to individual MCLs. And then the other 4 being a group of what we often call index PFAS. These are HXS, PFNA, HFPOGA, kind of often referred to by the trade name of Gen X chemicals, as well as standards that apply to mixtures or groupings of these compounds together, along with an additional PFAS compound, PFBS. These MCLs established compliance dates in the future with initial monitoring requirements required to be completed by April of 2027 after a 12-month monitoring period. And then with actual compliance with the MCLs in finished drinking water required beginning in April 2029. Well, again, there were questions about whether EPA would stand by these regulations as issued in 2024, whether they would seek to revoke any of them or alter the standards that were set. But on May 14th of last year, EPA announced a plan to keep at least its MCLs for PFOA and PFAS in their current form. But at the same time, the EPA announced its plan to keep those regulations. It also announced a plan to extend the compliance deadlines for the PFOA and PFAS MCLs. In particular, that announcement stated that EPA would at least propose to extend the compliance deadline by 2 years from April 2029 to April 2031, which would mean that those final standards would take effect about 7 years after they were first promulgated. That announcement from last spring didn't address any changes EPA may make to the monitoring period, although it seems reasonable at least to assume that might be included in the eventual proposed rule. At the same time, EPA also announced its plan to not only rescind the regulations for the 4 index PFAS, but also to reconsider the regulatory determinations it made for those 4 compounds. And as a bit of background, a regulatory determination is essentially the threshold determination that EPA makes, that it's going to regulate those compounds under the Safe Drinking Water Act. Now, the rationale it gave for doing that was to ensure that those determinations and the resulting drinking water regulations follow the Safe Drinking Water Act process which seemed to be a reference to criticisms that have been raised both in comments and in the litigation over those standards, that EPA had proceeded by simultaneously deciding to regulate those compounds and also finalizing the regulations rather than proceeding stepwise. EPA does have draft proposed rules for the compliance extension for PFOA and PFAS and the proposed reconsideration for index PFAS that have been sent to the Office of Management and Budget for review as part of the interagency review process. Those were sent over to OMB on February 24th of this year and are still currently under review as of my last check this morning. So we'll continue to monitor when those will come out and be published for public notice and comment. In the meantime, the DC Circuit litigation involving these standards is still proceeding. It's in the DC Circuit under case number 241188, and those standards have been challenged by both by a group of water utility groups and by industry petitioners, with various environmental group respondent interveners defending the rule. In September of last year, a few months after announcing its plan for reconsideration of these rules, EPA actually moved for partial vacatur of those portions of the rule that address index PFAS. And its motion for vacatur, which in essence sought for the court to vacate those portions of the rule, was based on the legal arguments that I just mentioned about the timing of the regulatory determinations for those 4 index PFAS. That motion was briefed over the course of last fall, and in January of this year, the DC Circuit Motions Panel unanimously denied that motion for partial vacatur, not addressing the merits directly, but simply saying that the merits of the case weren't so clear as to warrant summary action at this point. So it allowed the parties to finish their briefing and presumably move ahead to oral argument. In the meantime, the Biden-era rule remains in effect as it was finalized as the litigation moves ahead. Now, in a more recent update, on February 19th, EPA filed a new motion asking the court to instead sever and hold in abeyance the challenges to the index PFAS parts of this rule, while still allowing the challenges to the PFOA and PFAS standards to move ahead. So briefing on that motion has occurred over the past few weeks. In the course of that, both the utility petitioners as well as the environmental group interveners opposed this move to sever and stay the portions of the case involving index PFAS, generally raising arguments like that these arguments the EPA has raised for holding these issues in abeyance are speculative and don't support holding those issues in abeyance at this late stage of the case. Also pointing to potential hardship from holding those parts of the case in abeyance. That while those issues remain unresolved before the court, that these parties argue they are subject to, for the utilities, subject to obligations under those rules, and for the interveners, subject to potential harm from uncertainty about the status of those parts of the rule. EPA replied in support of this motion that to the extent there is any prejudice to these parties, it doesn't outweigh the benefits of continuing to hold those parts of the case in abeyance and let EPA address the issues involving the index PFAS through its administrative process, arguing in particular that the initial monitoring deadlines under the rule for these PFAS are still over a year away. So the DC Circuit hasn't resolved this motion yet, and it also hasn't scheduled oral argument of the case. So it remains to be seen what the course of this litigation is going to look like over the rest of this year. With that, I'll turn it over to Naveed to address the status of the CERCLA designations for PFAS and PFOA. Naveed?
Thanks so much, Andrew. So there's been a lot since the CERCLA hazardous substance designation of PFOA and PFAS and their salts and structured isomers to be considered as hazardous substance under CERCLA Section 102A. And that rule was made final in May 2024. and became effective in July 8th, 2024. And since then, we've obviously had a new administration, and there's been a lot of uncertainty as to whether or not what this administration would do in regards to the CERCLA hazard substance designation. But in September 17th of last year, Administrator Lee Zeldin announced that EPA is retaining the CERCLA hazard substance designation for PFOA and PFAS and continuing the approach from the prior administration. The 2024 rule designated PFOA and PFAS as hazard substances under CERCLA. And one of the changes that was intended, at least from what's been stated publicly is that EPA intends to develop CERCLA Section 102A, a framework rule that will provide a uniform approach to future hazardous substance designations, including how EPA will consider costs proposed designations. And this administration wants to sort of establish the rules of the road before any other future PFAS chemicals are designated. And so, as Administrator Zeldin stated in September of last year, when it comes to PFOA and PFAS contamination, holding polluters accountable while providing certainty for passive receivers that did not manufacture or generate those chemicals continued to be an ongoing challenge. I have heard loud and clear from the American people, from Congress, and from the local municipalities about this particular issue. EPA intends to do what we can based on our existing authority, but we will need new statutory language from Congress to fully address our concerns with passive receivers liability. The Trump administration is fully committed to ensuring all Americans have the cleanest air, land, and water. And so we can see here is, as Andrew alluded to earlier, this question of passive receivers that hasn't really been defined yet, and there's no clear definition under CERCLA, will be is a lot to come in terms of, especially from the congressional side. And as EPA has stated, it does not intend to pursue parties or entities where equitable factors do not support seeking response actions or CERCLA under its enforcement discretion and settlement policy for PFAS, and that which is issued alongside the rule in April of 2024. And it identified a few key entities, including community water systems, publicly owned treatment works, municipal separate stormwater systems, publicly owned municipal landfill, municipal solid waste landfills, publicly owned airports and local fire departments, and farms where biosolids are applied to land. However, the EPA's enforcement discretion policy does not protect entities from state enforcement actions or third-party contribution lawsuits from other liable parties seeking to recoup costs. And so, therefore, the administrator is alluding to congressional help in potentially a carve-out for passive receivers. So what does this mean for businesses and industry, potential liability? And there is ongoing litigation in the DC Circuit under the Chamber of Commerce of the United States versus EPA, and that's case number 24-1193. And this case recently had oral arguments in January 2026, and the current posture is that the case is waiting decision from a three-judge panel in the DC Circuit. And this case challenges EPA's May 2024 rule designating PFOA and PFAS under CERCLA Section 102A. And just to kind of give you kind of a procedural history, the petition for review was filed by the U.S. Chamber of Commerce and several other industry groups, and in July of 2024. And as alluded to earlier, in September, EPA announced that it will retain the hazard substance designation. There were several stays granted to allow the Trump administration to review the hazard substance designation. And recently, in December 2025, EPA filed its final brief, and oral arguments were held in January 2026. And some of the key legal issues presented in this case were whether EPA reasonably interpreted may present substantial danger under CERCLA Section 1 and 2A, whether EPA adequately considered the costs and benefits of the designation, and whether EPA violated notice and comment requirements by disclosing new reasoning and quantitative estimates only in the final rule. And there were a number of interveners for environmental groups, including the NRDC, Environmental Justice, among others. And at oral arguments, the three-judge panel seemingly alluded to that they may uphold EPA's decision to designate PFOA and PFAS as a hazardous substance under CERCLA, and keeping polluters on the hook for cleanups. One of the main questions they sort of discussed in oral arguments is whether EPA permissibly designate these chemicals as hazardous. And the judges stated they looked at the science, and petitioners, argue that the petitioners didn't really contest much of this. And the industry's core arguments was that EPA had internally inconsistently held or found how it treated costs and benefits. And EPA or DOJ's position was that the cost analysis was not really a central justification for the rule, but rather the estimates and analysis provided were illustrative. And the interveners kind of agreed with that analysis as well, where it's found that EPA list, when an EPA lists a Superfund site, has no idea how much the remediation of that site is going to cost. And so the key takeaway from this litigation so far, again, we're still waiting as of this morning, but the panel, at least in oral arguments, seems skeptical of industry's arguments, and signaling that the designation may be upheld. And so in EPA's final brief I mentioned, filed in December of last year, it focuses on what happens if this rule is vacated. And it seems to be sort of from this quote and from among the arguments in the brief, that EPA will sort of, even if the designation is vacated, EPA will still seek alternative legal pathways, in this case as a pollutant contaminant, and finding, especially in instances of a finding of imminent substantial endangerment determinations. And that all goes to say is that, although this fallback approach would really impose additional burdens on the agency, it's clear that the EPA really doesn't have any intentions of backing down from its efforts to address PFOA and PFAS contamination. So that kind of gives an overview of where the CERCLA hazardous substance designation is currently. And I'll turn it over back to Andrew for TSCA changes.
Thanks, Naveed. I'll quickly run through one final update from last year's developments having to do with EPA's reporting rule under TSCA 8A7. This was a rule that was actually required by Congress under the 2020 NDAA that added this provision to require that EPA adopt a rule requiring each person who's manufactured a chemical substance that is a PFAS in any year since January 1st, 2011, to report certain information that's spelled out in other provisions of TSCA Section 8. So this rule is required by law, and the Biden administration issued the current reporting rule in October of 2023. That original rule included a 6-month submission period for data from required reporters that was set to end in May of 2025. That reporting period has already been extended twice primarily, I believe, for issues with the online reporting platform for data, and currently is set to run from April 13th through October 13th of this year. Well, there are outstanding questions not only about the compliance timeline, but also who would be covered by this rule and whether the new administration would issue any amendments to its scope. And in fact, on November 10th of last year, EPA released proposed amendments to this TSCA rule to amend the requirements, including both the reporting period and the reporters subject to it. Now, the type of information covered by this rule includes things like the uses of PFAS and PFAS-containing materials, the production volumes that are out in commerce, any byproducts that result from PFAS manufacture and importation, known disposals and exposures, as well as information that's already in existence and in possession of the reporters on environmental and health effects of PFAS. Now, in the proposed amendments published last fall, they would include some significant changes to the reporting requirements by adding several specific exemptions to the rule's coverage. These include a de minimis exemption for PFAS contained at a concentration of less than 0.1%. And EPA's rationale here was essentially that given the retrospective scope of this reporting rule, that the reporters would be unlikely to have data actually identifying PFAS in their products below that threshold amount. There's also an exemption for PFAS present as a byproduct, an impurity, or a non-isolated intermediate exemption in products manufactured or imported. An exemption for PFAS's presence in research and development materials. And again, EPA's rationale here is that these kind of R&D uses and products would have limited relevance for the kinds of commercial occurrence and exposure that EPA is looking for in its potential TSCA actions. And then finally, I left it off this slide, but the proposed rule included an important exemption for imported articles. These are essentially finished products imported that would otherwise be subject to this rule, but that EPA found would be unlikely to have information available that they could report regarding the PFAS contents of their articles. This proposed rule also included a reporting extension. So now, rather than the 6-month period running from this April through October, if finalized, the rule would include a 3-month period for submittal of responsive reports. It would start to run 60 days after the effective date of any final amendments that are enacted. Again, this was proposed last fall. EPA is working on the final rule at this point in time, but has not sent a draft yet to OMB for review. So we don't yet know a timeline for EPA's projected finalization here. All right, so that wraps up our discussion of last year's events. And before I go on, I should mention something that I forgot to say at the beginning of the discussion here today, which is that if you have any questions as we go through our presentation, please feel free to add them to the Q&A box. We will either address these, depending on how many we receive as they come up, or we can try and discuss them at the end together as a panel with the time remaining at the end. So sorry, I should have mentioned that at the outset. Okay, turning now to our trends for this year. We could have picked from a broad range of potential actions to discuss here, particularly at the state level, where states are continuing to push actively to address PFAS at their own level, kind of in parallel or going beyond where the federal government is taking action. And at the state level, this includes a broad range of potential actions, anything from adopting their own limits for PFAS in drinking water or groundwater, to targeted consumer product bans or limitations on PFAS content. But for purposes of today's discussion, one of the things we wanted to focus on was state efforts involving use of biosolids. And here in particular, I wanted to hand it off to Preston to talk about some of his own experience and expertise on this issue. So you can take it away, Preston.
Thank you, Andrew. Again, I'm Preston Bryant with McGuireWoods Consulting. I'm in Richmond, Virginia, and we are seeing emerging PFAS trend, if you will, seen in states that are increasingly regulating or restricting or even banning land application of biosolids that are produced by wastewater treatment plants. Of course, all wastewater treatment plants produce sewage sludge. It's a natural byproduct, and when treated and processed, it can be land applied as an inexpensive fertilizer or soil additive to agricultural fields, farm fields. Farmers typically very much like biosolids. It saves them a lot of money given its low cost. All of this is done under EPA regulation. Backing up a bit, let me just say there are three ways that wastewater treatment plants typically dispose of biosolids. They either landfill them or compost, they incinerate, or they land apply. In Virginia, for example, we land apply 2/3 of biosolids, and only 1/3 is incinerated or put in the landfill. But in recent years, and I'll go through, I got 7 slides here, 6 remaining. In recent years, we've seen a number of states where environmental organizations have been especially active, raising concerns about PFAS levels in biosolids that are land applied to ag fields that then may result in experienced runoff into nearby waterways. But biosolids has a long history of being land applied. Even if you go to your local lawn or home store, you can find biosolids that have been especially treated in bags that you can purchase or jugs there. But in numerous states, and again in recent years, have been enacting additional regulations or legislation. And in Virginia, again, we apply, land apply 2/3 of the volume, only 1/3 is incinerated or landfilled. And in Virginia, we've been wrestling with this. If there are overly aggressive restrictions or even a ban on biosolids, what do we do with 2/3? Because we only have 5 incinerators in Virginia. They are capacity limited. Landfills often don't want additional biosolids for liability or capacity reasons. So it's been a particular challenge here. And I'll get back to Virginia in a few slides. A few years ago, Maine was the first state, I believe they were the first state to have an outright ban on biosolids, sewage sludge derived products that are land applied. Connecticut followed a couple years later in 2 different bills, one in 2024, one in 2025, that affected an actual ban. Rhode Island doesn't do that much land application of biosolids, but they did pass a House and a Senate bill last year requiring more testing and submitting those test results to state regulators, and regulators can, if they see excessive levels, and I don't remember what the levels are, they can deny land application permits. New York has been especially active last year and this year. In the 2025 session, they enacted regulations on industrial and wastewater treatment facilities that are producing biosolids, getting more testing there, if there to be a soil additive, that is. 2025 also, there was additional legislation proposed to do more testing and reporting around groundwater. And then there was a bill proposed in 2025, and again, it did not pass in 2025, and it's under reconsideration in 2026, to enact a 5-year moratorium in New York State on land application of biosolids. Again, it did not pass last year. It is under consideration this year. Their legislature is still in session. Mississippi is they had legislation, this is in 2026, have filed legislation for more testing and setting PFAS limits for land application. My last couple slides will focus just on Michigan, Maryland, and Virginia. Michigan, and this seems to be a kind of a more discerning approach. Michigan has done a lot of work on biosolids and land application. They took a very stepwise approach. They've done a lot of data collecting. They've studied it, and then they have enacted the proposed legislation or enacted legislation based on like 5 years worth of data collection and study. And you'll see there, if particularly for PFOA and PFOS, if it's more than 100 parts per billion, you cannot land apply. If it's between 20 and 100, you can reduce land application to 1.5 dry tons per acre. That's pretty slim, pretty slight, pretty thin, I should say, land application. Some question if a mere 1.5 dry tons per acre has sufficient nutrient value. And then if it's less than 20 parts per billion, there's no land application. So Michigan was the model that some other states have begun to follow or take into account, most notably Maryland and Virginia. On Maryland, they had legislation introduced last year, taking this sort of tiered approach. It did not pass last year. It got great consideration. The wastewater treatment plants, the industry had a lot of concern over it and how they would comply. This year, again, Maryland's legislature is still in session, so I don't think this legislation is yet final, but we think it's going to pass. So they've taken even more of a stepwise approach, still a tiered approach, beginning in October of 2027, so a year out. You can see that if it's Michigan, you remember, was greater than 100 parts per billion, there was no land application. In Maryland, it's half that. So it's more aggressive. If it's greater than 50 parts per billion, you're not allowed. Between 25 and 50, it's reduced. And then less than 50, there's no, less than 25 parts per billion, there's no restrictions. They ramp that up or ramp it down, depending how you look at it, beginning in 2029, down to anything over 25 parts per billion. You can still land apply, but you need to work with regulators more, develop a mitigation plan, and anything less than 25 parts per billion, you're free to go. My last slide is on Virginia. Virginia's legislature just adjourned 3 days ago, and they have it was well known that a number of Virginia legislators were collaborating with Maryland legislators on how to approach it, and you can see that the legislation is pretty similar. Virginia legislators had concerns that if they didn't have something pretty similar to what Maryland was considering, then Virginia might be getting a lot of land application from wastewater treatment plants in Maryland coming across the Potomac. Virginia took a little more nuanced approach. You can see that this in the first beginning 2027, they test for PFOS and PFOA separately. But in 2029, they measure those levels cumulatively. But you can see the schedule there, greater than 50 parts per billion, you're not allowed to land apply. Whereas Michigan had reduced land application at 1.5 dry tons per acre. Virginia felt that 3 dry tons per acre was more appropriate in getting some nutrient value on the land application, not spreading it overly thin. And then in 2029, you can see that there's a ramp down, if you will, of land application in Virginia, down to, again, 25 parts per billion or less, no restrictions. So let me turn it back to Andrew or Naveed.
Yeah, thanks a lot, Preston. Next, I mentioned that states in general are pursuing different kinds of bans or regulations on consumer products containing PFAS. And given that we just wrapped up the 2026 Winter Olympics, we thought it'd be interesting to discuss some of those specifically in the context of sporting goods. So Naveed, I'll hand it off to you to address those.
Thanks so much, Andrew. So as Andrew mentioned, PFAS containing sort of ski wax has been used for decades because they provide ultra low friction and help skiers and snowboarders glide faster, especially in wet snow conditions. However, recently the International Ski and Snowboard Federation banned PFAS containing waxes in 2023, and to address specifically to address concerns over human exposure and environmental contamination. And the International Olympic Committee followed suit in the most recent Winter Olympic Games. And so day 2 of the competition, Japanese snowboarder Masaki Shiba was disqualified, ending probably his last Olympic run as he's 39. And on day 4, 2 South Korean skiers were disqualified after the women's sprint classic qualifier. In all these cases, their scores were voided because of their use of PFAS-containing fluorinated wax. The Korean Olympic Committee blamed supplier mistakes, and Shiba claimed that he had used the same equipment in prior events without any issues. And so researchers have found that PFAS contamination in soil at ski resorts, on slopes after competitions, and even on Mount Everest, likely deposited from outdoor gear. And these findings, provide that why regulators are so interested in PFAS and recreational equipment. So moving to the United States, there's several states that ban wax or PFAS-containing wax, including Vermont, Colorado, Connecticut, Maine, New Hampshire, New Mexico, and Rhode Island. And this is part of a larger movement of restriction PFAS across industries. And this, particular example of ski wax disqualifications at the 2026 Olympics represents a high-profile example of how PFAS regulations is affecting real-world outcomes, especially for those competing in these sports. Also, we've seen bans in artificial turf. So several states have enacted laws restricting PFAS in artificial turf. And artificial turf has been allegedly found to be a source of PFAS exposure for athletes and communities, particularly through direct skin contacts, inhalation of dust and particulates, and as well as leaching into soil and groundwater. And PFAS in artificial turf may originate from the coatings, but also backing materials, infill, and other manufacturing inputs. And this kind of raises concerns even where PFAS is not intentionally added. And so several states, including Colorado, Vermont, Maine, New York, and Rhode Island, have enacted specific bans of either selling or distributing artificial turf within a specific time period. Additionally, last month, there's been some litigation around this as well. And so the U.S. District Court denied a motion to remand a lawsuit brought by former baseball players claiming PFAS exposure from artificial turf in their stadiums that allegedly caused various types of cancer. And so there's just a lot happening in this, both on the regulatory side, but also on the litigation side. And we're seeing something similar in outdoor apparel. Specifically, several states have enacted laws restricting PFAS in outdoor apparel and textiles, with approaches ranging from outright bans to labeling and disclosure requirements. And several states have carve-outs for outdoor apparel for severe wet conditions. And that's defined, broadly as extreme and extended use products designed for outdoor sports experts, providing protection against extended exposure to extreme rain or immersion in water or wet conditions. And these restrictions are not marketed for general consumer use most of the time, but they target specifically expert level gear where PFAS-based water repellency has historically been considered essential. But even in that case, several states, including Connecticut and Rhode Island, have considered bans for outdoor apparel specifically for severe wet conditions. And so going back to the federal level, mentioned earlier how Congress has been really considering whether or not to provide a carve out for passive receivers. And there's been several hearings in both in the Senate and in the House. In November 2025, the U.S. Senate Environmental Public Works Committee had a hearing on examining the future of PFAS cleanup and disposal policy. And Senator Capito said that Congress has to come together to enact a bipartisan solution to minimize PFAS contamination, but also has to develop a path to destroy PFAS and protect passive receivers. And so, as I mentioned earlier, there's no clear definition of what passive receivers, who would be considered as a passive receiver. But, without a sort of statutory exemption from Congress, the enforcement discretion policy that EPA put out does not shield passive receivers from at least third-party circle liability. And we're seeing some interesting things happening, especially on the state level as well on this front. So in Georgia, the Georgia legislature is currently considering a bill that would shield certain industries from PFAS lawsuits. House Bill 211, known as the PFAS Receiver Shield Act, specifically defines PFAS receiver, meaning any person or entity, not including a person or entity that is also a PFAS manufacturer, and it applies for users or for PFAS substances in manufacturers of goods or in agriculture, or receives or obtains goods or products that contain PFAS, purchases or owns goods or products that contain PFAS, and is licensed, permitted, and regulated by the EPD of the state. And so here we have the liability protection for absent gross negligence. No PFAS receiver shall be held liable for damages in action involving a liability claim arising from or related to its intended or incidental use, receipt, or disposal of PFAS. So if this is enacted, it would be the first of its kind, limiting liability for almost everyone, all entities except PFAS manufacturers. And there's been, some pushback from this as well, including from environmental groups who, and residents who oppose the bill. And recent news articles have stated that the liability, especially for the carpet industry, would be, sweeping the contamination under the rug. So with that pun, I'll turn it back to you, Andrew, to discuss the updates and the disposal destruction guidance.
Thanks a lot, Naveed. Just real quickly, I want to hit on two items that we're watching at the federal level for action in 2026. One, I briefly mentioned earlier, which is the EPA is planning a new updated guidance on destruction and disposal of PFAS-containing materials. This is something that EPA, under the new administration, has said it's going to make a priority to update more frequently. And there are already lots of questions from folks facing, for example, compliance deadlines under the Safe Drinking Water Act MCLs or other obligations on how to treat PFAS and then what to do with the treatment byproducts once they have done that. So this updated guidance will help provide some additional information on that. EPA's guidance document on this issue was most recently issued in 2024. And these guidance documents are not enforceable. They don't impose enforceable requirements. What they're meant to do is provide information to decision makers on the best science and methods for selecting the disposal method that you're going to use. The most recent guidance addressed options like incineration of PFAS-containing materials or other kinds of heat treatment like reactivation of activated carbon, and landfill disposal and underground injection, and gave comparative information about the availability and effectiveness and other remaining scientific and technical questions about these methods. The updated draft guidance went to OMB for review on March 3rd and is still under review there. When EPA issued its 2024 guidance, it provided an opportunity for public comment before finalizing it. And I would anticipate EPA would take a similar approach here. And then finally, I'll note under the Clean Air Act, there is an existing petition before EPA that was filed by 3 states, North Carolina, New Jersey, and New Mexico in August of 2024. This is a rulemaking petition, so it's requesting that EPA take action under the Clean Air Act to list the 4 PFAS compounds you see here, formerly as hazardous air pollutants under Section 112 of the Clean Air Act. EPA has not responded to this petition yet, and there's a current dispute about whether its statutory deadline to do so has passed. The Clean Air Act allows EPA 18 months to respond to petitions of this specific kind, seeking listing of a pollutant as a hazardous air pollutant. But EPA typically takes the position that that clock doesn't begin to run until it considers the petition to be complete. So EPA's view is the clock isn't running yet. The states seem to be taking the position that it is, and in fact that the deadline passed last month. So where that leaves us is that these states could potentially explore filing an unreasonable delay suit, seeking to compel EPA to actually respond to this petition and decide whether it's going to regulate PFAS under the Clean Air Act or not. And if they're successful in that effort, that could certainly trigger some new and significant regulatory changes, in particular given that under this specific provision of the Clean Air Act, if a source is regulated for any HAP, any hazardous air pollutant, then it needs to be subject to regulations for every hazardous air pollutant regulated from that source category. So the implications of this finding could be fairly significant for categories subject to regulation now. So that takes us to the end of our prepared portion of today's presentation. Again, I mentioned at the beginning, this is just the first in our series of Contaminants Compass CLEs for this year. You can see a brief preview of the topics we're planning to cover later this year with presentations coming up in May, August, and October. And I'll leave it here for our prepared remarks. We have just a few minutes left for questions. I'll answer a few that we got through the chat very quickly, but if you have others that are on your mind, please drop them in the chat now, and we can either address them now, or if we run out of time, we can always follow up with you later. We'll be able to see the questions you submitted and can get back to you with responses. But the first general question that we got is simply whether this presentation will be available for attendees. The slides themselves will not be sent out to participants, but we do post the video of the presentation for you to view again on our McGuireWoods website. All you got to do is go to our website and search for our PFAS and emerging contaminants team, and you'll be able to follow the links there to our events page and see the link for this presentation. We also got a very good question from one participant looking back to the TSCA reporting rule that EPA is looking at amending, and they asked, what if the proposed rule under TSCA Section 8A7 is not finalized before the beginning of the current rule's 6-month reporting period? So again, as I mentioned, that period runs from mid-April through mid-October of this year. So it's a very good question. What do we do if the amendments aren't finalized before then? In general, I would say, one, that it is a reporting window. So the period to report is open until October of this year. So there would be an ability to report later on during that window, even if EPA's final rule isn't finalized before mid-April of this year. The other thing I would say is that it's possible you could see independent action from EPA if necessary to just address the reporting deadline. If EPA finds that it's not able to finalize its actual substantive amendments in time to provide meaningful relief here. We have seen this administration take similar kinds of steps with deadlines under other rules that it's been considering amendments to. I'm thinking, for example, in the Clean Air Act space, there have been impending deadlines coming up under the greenhouse gas reporting rule and under EPA's certain regulations EPA had issued for emissions of methane from the oil and gas sector. And EPA has taken some targeted action to provide relief from impending deadlines when it hadn't completed its reconsideration yet. So you could see some pressure for EPA to do something similar here if necessary. And with that, I see that we've come up on the hour mark. Again, if you have any other questions that you'd like us to follow up on about items we discussed today or anything else about regulatory developments in the PFAS space, please send them our way and we're happy to get back to you. We appreciate your joining us for today's presentation. And with that, we'll let you go. Thank you.
Thank you.